Do you approach constitutional cases any differently than statutory administrative cases?
Yes. Statutory cases tend to be pretty straightforward for the most part. Administrative law cases, they have their ambiguities, but it's fairly. I think you read the text and you sneak a peek at legislative history. Why I'm thinking that looking at legislative history, just that movie Grant still is. Why is that in my head? Where he says that he's invited to this party. He's about, what would I wear? I don't know why that's in my head. But at any rate, I think that the constitutional cases are a little bit harder.
It wouldn't come to you if they were easy.
They're hard. I just look at my hair. What's left of it. It's hard. There's some of these things you just don't want to see them anymore. It's like, let me out of here. We grant cert on it. I remember when we were doing the war cases. Those are really, really hard cases. And I guess you sometimes get a little disappointed the way people talk about them, as though you're for this or you're for that, and you're just trying to use a methodology. I think Professor Freed was talking in his class today about these various interpretive models, which I thought was really interesting. Because, you sit there and you're trying to use existing precedent to handle something that's different. And what model do you use? What approach do you use? And so, yes, they tend to be fairly difficult. And it does matter which one you choose. As I was saying this, he's saying to students today, that you can disagree with the models, but you got to use something. You got to have some mode of analysis.